Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within for the Commonwealth. Draw near, give your attendance, and you shall be heard. I state the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the October 10th, 2025 sitting of the Massachusetts Appeals Court. My name is Catherine Hand. To my right is Justice Hodgins. To my left, Justice Tan, and we're your panel for today. We have 4 cases on our oral argument list. In each case, customarily, each side has 15 minutes. There is no rebuttal. I know that there is one case that's on for today in which there is a 10-minute split for each of the arguing parties. I'm aware that there are both attorneys here representing the parties. There are also certain litigants here. We appreciate your attention and interest in the cases. We would like you to know that we have had the opportunity to thoroughly read all of the materials that have been provided to us. All of our materials are on these iPads that we have with us, so if you see us referring to the iPads, it's because we are referring to the case materials in each of your matters. You will also, when you have an opportunity to stand at the podium, see that there are 3 lights that are to the right of the microphone, green, yellow, red. The green light will activate when you begin your argument, and it will remain on until there are 90 seconds remaining in your argument. At that point, the yellow light will go on. When the red light comes on, your time has expired, and unless you are answering a question from one of us, I would ask that you wrap up your argument at that point. Many of the cases on today's list, in fact all but one, I think, involve either total or partial impoundment. I would ask for those of you who are involved in cases involving impounded material that you not refer to the impounded material in detail. For those that are completely impounded, please don't refer to the parties' names. Please use titles, mother, father, child, or identify the parties in some other way. So with that said, I will call our first case, which is Kristen Alani Aprusesi versus Antonio Siniscalco. That's 24P1466. Good morning.
Good morning, Your Honors. Juliet, may it please the Court, Juliet Davison for the appellant petitioner, Kristen Alani Aprusesi. This is an unusual case, and the appellee I gather, is not appearing in the appeal. So let me start by summarizing quickly the legal argument and then providing you with some factual highlights and then getting into more detail on the legal front. The basic legal arguments that are presented in our brief are, number one, that the probate court did not have the authority on appellant's petition to be appointed as the general guardian for her daughter, Isabella Siniscalco, to enter essentially what was a visitation order. The options on a petition for a guardianship are to enter a general guardianship, a limited guardianship, or to not allow the petition. And this was, as I'll get into, an unorthodox proceeding.
Can I ask a question? So how would one go about, from your perspective, what would be the proper way for a parent to request visitation in this circumstance? That's
a good question, Your Honor. The correct way to approach the issue would be, and it's referenced in the probate court's supplemental decree, which is at Record Appendix 95, would be to file a petition to modify, limit, or expand the guardian's authority. That's provided for in the statute. There's a form that could be filed, and that is the proper procedural approach. The court referenced that what he was essentially trying to do was short-circuit that procedure. And you can see, he says, the court noted in the decree, the court had reserved its right to issue supplemental judgment without the need for anyone to subsequently file a petition to expand, limit the guardian's authority with its attendant cost, time, and use of court resources. So he was essentially trying to short-circuit that, that procedure. What I will say about that is that the guardianship statute, and if you look at the decree that was entered at the end of July, nunc pro tunc to a date in June, the decree, let me just get that in front of me. Purported to reserve the right for the court to issue this supplemental decree. But if you look at Record Appendix 171, which is the form limitations to guardianship, if in the limitations towards the bottom, then there are boxes to be checked, towards the bottom, to determine with whom to have friendships and visitation. So that is the issue. The court could have entered a limited guardianship and reserved that power for Isabella. And the record, what's a little confusing is the record evidence in this case, both from the GAL and from the court-appointed counsel, was that Isabella was amply able to say what she wanted. Both of them reported in the record that she said she did not want to see her father.
So could I ask a question that follows up on that? The limitation on the guardianship would limit the guardian's ability to dictate over Isabella's preferences. Is that correct?
Correct.
And the petition that you're talking about, that the father, you're suggesting, should have filed, would have been a separate layer of judicial control over Isabella's decision-making apart from the guardianship? Or would it be a directive to the guardian to require?
Or is it the mechanism that you're?
No, I understand the question. I think that it's the mechanism, and that essentially the court was trying to short circuit to say, you don't have to go through this procedure. I'm going to act as if you had and take this authority away from the guardian.
But doesn't the judge have the broad equitable authority to do so in terms of, essentially, I mean, you're correct, it wasn't technically a limited guardianship, but in effect, it was, right?
I understand that that's what the court was trying to do. I don't believe that the statute contemplates that. And what I will, and that sort of is connected to the second critical legal issue, which is that the court adopted in this sort of what I will call hybrid, unusual procedure, the court adopted the GAL's recommendations to essentially take away from my client, who's been the sole caretaker for the severely disabled daughter since her brain injury in 2010. Literally, the child, Isabella, cannot be outside of her presence, took away from mom the right to make any decisions about visitation with the father without an evidentiary hearing, without an opportunity to cross-examine.
So can I ask you about that?
Yes.
At the hearing, trial counsel for mother actually didn't object to the actual admission of the GAL, nor did she ask for a continuance or ask for the GAL to be produced or, again, ask for another date to summons in the GAL to cross-examine, the GAL or present witnesses herself. And in fact, the judge asked and said, counsel, what do you think? And she says, and this is Record Appendix 1, page 79, the attorney for mother says, well, we have no issue with the father, so some of the recommendations in the GAL report with the father attending workshops, she goes on to say we have no objection to that, there may be some contact in the future, and then later goes on to say, and I don't think there's anything further that needs to happen, right? And so there was no request at all at the hearing for that opportunity.
This is counsel for Isabella, not counsel for the petitioner.
I'm sorry, okay.
Yeah, and counsel for Isabella, court-appointed counsel for Isabella aggressively advocated against her interests.
Right. Right.
She,
But trial counsel for mother, though, there's,
well, I'm not going to take the position that it wouldn't have been better if.
but there's no request, though, correct?
Correct.
That part, there's no request.
And a better record would show that that request was made. Nevertheless, the court has an obligation to provide the opportunity to mom and.
But what does that mean, obligation? So they're here for a hearing, right? And the jail report is discussed. Everyone's had a chance to respond and give their position. And so at that point, if the mother wanted to object and also ask for the opportunity to cross and say, I vehemently disagree. I want to cross, everything in here, we don't agree with this, it's wrong. I want to cross and I want an opportunity. She had the opportunity to do so then and did not, correct?
I'm not going to disagree with that, Your Honor. The argument that I'm presenting is that the court should have provided, given the draconian effect that this order has on my client and her daughter, who who is traumatized and has it's all in the record. This is not something she wants. It's not something that is medically indicated in the medical certificate that was on file with the court. That when the court held the hearing, you can see in the record, he said, well, I'm not sure why we're here. I guess it's to talk about whether we whether we can agree on any of the recommendations in the GAL report. That's a pretty informal approach to a proceeding with such an extreme outcome. And so my submission to the court is that the court should have provided that opportunity to counsel under the Gilmore case. And there's obviously, we cited all the cases in our brief that hold that the parties are entitled to cross-examine the GAL in a proceeding like this.
The hearing day, the non-evidentiary hearing day that this was on for, what was it on for that day? Like, why was the judge confused as to what it was on for, or seemed to be confused?
If I wasn't there, but my perception from reading the record is that, he didn't recall that he had appointed the GAL, that it's a very busy court, and he had, if you look at the docket, these orders are entered on the docket well after they're signed. And so, like, for instance, with the initial order appointing my client as the general guardian, I believe the court.
You're talking about the temporary guardianship that
the initial. She was appointed as guardian. July 30th is when the court signed the order, nunc pro tunc, to, I believe it was June 11th, and then the order is actually entered on the docket after that. So there's my perception, not having been there, of what happened is that it's a very busy court, and the judge was trying to remember what was pending and what had happened in the case. That's my sense. But again, that sort of highlights, and I take your point with regard to counsel. There's a fair, things are happening in real time. It's a very crowded courtroom with people with all kinds of problems that need to be addressed. And even the judge is showing some confusion about what's supposed to happen that day. So would we have a better record if counsel had made that request? Yes. Is that determinative of the outcome of the case? I submit it absolutely should not be. That given the effect of this order on my client and her daughter, which is, I think I've described in the record, but is overwhelmingly negative and would cause severe medical problems for the daughter. Given all of that there should have been an opportunity to have the GAL present and cross-examine the GAL.
This is what I'm trying to understand, because if your client had shown up that day of this hearing that took place with a witness, like that there was a witness that, you know, had some information that would be helpful to the court, I'm just trying to understand, would this go forward as an evidentiary hearing, or did another date have to be, oh, you have a witness, well, we're going to have to pick another date? Or was it, I'm just trying to gauge, were the parties surprised by how all this went down, or was there an expectation that, oh, we're going to have a further hearing on this?
I think from my client's perspective, and again, I wasn't there, but from counsel's perspective, what the court said is we're going to see if we can agree to some of these recommendations of the GAL. And you can see from petitioner's counsel in the probate court said, you know, there are some things we can agree to. We can agree to that Antonio should go through all of this training that he failed to do 10 years ago when we were in the probate court and there was a custody proceeding. There's all kinds of, there's steps we can agree to. And I believe that that is the extent of what our side of the case understood what was going to happen that day. I can't speak for Antonio, but I don't think he had any expectation in any regard. And I think that the transcript shows that the judge did not have clarity on what was supposed to happen that day. So that.
Can I ask, practically speaking, right, your client could go back at any point, and maybe she already has, I'm not sure, to ask for that, to address, right, the supplemental order and ask for it to be modified or removed. And in fact, I believe the father filed a motion, as you're probably aware, to voluntarily withdraw the appeal, is what he called it, right? We have something in the record here that
Yes.
he sent and said, in which he says he wants to withdraw his appeal. She's verbally expressed she does not wish for me to be involved. I'm choosing to respect her wishes. So I guess I'm asking, practically speaking, your client could go back to the probate court and ask.
Yes. She could do that. Given what has happened in the probate court, the reason we are here on appeal is because there was legal error in entering these orders, and we would like to have them reversed.
I understand the argument.
There could be, these visitation issues came up in 2012 to 2014. They were resolved in the Antonio's custody and visitation proceedings. They were resolved by agreement with him not participating in Isabella's life. Isabella's 20, and she's got a long road to hoe. So that's why we're here on appeal. We would like to see these orders reversed.
Thank you very much.
Thank you.
The matter is submitted. Our second case this morning is 25P0096, Department of Children and Families versus Child and Others. And I understand that this is the case in which there is a split 10 minutes for each of the three arguing entities.
May it please the court, good morning, Your Honors. My name is Attorney Svetlana Gerova-Wilson. I represent the father, and this is also an unusual case because father is appellee as to two issues, the issue of parental unfitness and the issue of the denial of his motion for abuse of discretion. And he's appellant as to those issues, and he's appellee on the issue of best interest of the child. Now, this case exemplifies the extraordinary power that the state has over the course of a child's and parents' lives based on their placement decisions. Those decisions can fundamentally shape a child's relationship and their identity. The core issue here is, can a parent be found unfit based on insufficient parenting time? And I submit to you.
Counsel, can I just ask you, just because I know we don't have a lot of time,
Yes.
So it wasn't, the judge didn't just base the decision to find him, your client unfit for sort of the amount of visitation, right? I mean, and I understand it's a very difficult situation for your client because he lives out of state and the travel and he works and so and actually the judge acknowledged that in his findings, right? And he said, I don't totally fault the father, right, for not being able to make all of his parenting time. But he also refused some visits, right, in which the department offered him, you can come to a visitation center and you can actually do some virtual visits, and he didn't want to because he said he didn't like visitation centers and he didn't like the idea of having to see his son virtually in the foster home, right? And there were other reasons he found him unfit. He cited the failure to complete or give the neuropsych evaluation, also his failure to recognize the importance of the foster family in his son's life by saying he would, cease any contact with them if you were placed back with the father. So there were other reasons besides the visits, correct?
So, Your Honor, yes and no. I mean, yes, there are other reasons that the judge pointed to, but I'll try to address them one by one as quickly as I can. In terms of the compliance with services, the neuropsych eval, yes, this is correct. He did find that was part of the reasons why the father isn't fit. However, at finding of fact 330, the judge also found that the father does not have any long-term condition, a substance abuse disorder, or mental illness likely to persist and affect his ability to parent.
Right.
So basically, that's whether or not he produced his neuropsych eval does not have any bearing on his ability to parent his child if he does not have mental illness, which the judge found that he does not, to parent his child. Also, in terms of the father's denial to attend some of the visits, I mean, I know that there's some discrepancies in how both parties view the facts, and the judge is entitled to deference. However, I would like to point your attention to adoption of Leland. It's cited, and I can give you the citation, but I don't have much time, so I'll skip that. It was a very similar case where father lived in Connecticut, and he did not have, he did not visit with the child. He sporadically visited he also did not produce drug screens, he did not do domestic violence program, and the judge found, the panel found that finding relating to the sporadic visits, while not clearly erroneous, suffers from a lack of close attention to the evidence. And I submit to you that's exactly what happened here. Yes, father did not visit as often as he should. Yes, he is responsible for some of the missed visits. But what the judge did not consider was the deteriorated relationship between father and the department. Father, if you recall from my statement of facts, father did well at the beginning. He went every week, he drove 4 to 6 hours, but then his ICPC was denied. And he started feeling discriminated. There was at one point, his social worker told him, watch your behavior because as a black man and as a Muslim, people will take things the wrong way. And this is his concern. This is his concern. His concern is that his prior 20-year-old criminal history was held against him, that his prior 23-year-old now, DCF history was used against him. Whether or not this was objective discrimination, I don't think it's important. What's important is that's how he perceived it, and the judge did not consider that deteriorated relationship with the department. And most importantly, father asked the court to order extra visits and to order a specific place where the visits would occur. And the judge denied his motion, basically
the judge took into account the impact that the effect that particular request would have on the child as far as how long the child would have to be in transit to get to those locations? He didn't state specifically. I imagine that would have been one of the reasons. However, the judge had the authority to order a parenting time, a parenting schedule, because it was very clear that the department and father could not work one out together. And that would have solved that problem. And also, also the judge could have done something else. He could have found, he did not have to find father unfit. He could have ordered a reunification plan, allowing for visits or transition plan between the foster family and father. He could have ordered visits with his family. There's many things that could have been done. But the judge essentially found that the father had not progressed to the point of having anything other than supervised visits, and that was the result of the father's situation, to some degree, based on his work requirements
So-
and also his choices.
Well, yes, it was partially, so the father was held partially responsible. In the judge's findings, he states that he's partially, and I do have the finding here, but I still don't have a whole lot of time. But he only found father to be partially willful.
You recognize that it wasn't all
Right,
intentional.
it wasn't all his fault.
Right.
Yes, but the effect was, in the end, the effect was that it was held against him, and only him, because the department doesn't, they, for lack of a better word, benefited from those findings because the child is in their care.
But again, it wasn't the only finding. That was I understand that's the argument, but would you agree that there were also findings about the father's relationship, as you pointed out, with DCF, the aggressive conduct toward the two, at least, of the social workers, as well as certain other conduct of the father?
Well, I'm not certain if the word aggressive was used. They perceived it as aggressive, but
My word, not
it's,
the,
well,
I'm dead to take it out of the record.
Right, I'm not certain. My apologies, but so failure to cooperate with DCF is in and of itself also cannot be fracture of unfitness. And again, this is exactly what happened in adoption of Leland. The father there did not want to work with DCF. He did not like how he was treated. He did not like how the child, how he was lured into Massachusetts so that the Massachusetts DCF can take custody of his son. But even that was not, the panel found that even that was not enough to make a finding of unfitness. So, I agree, it was not the only reason, that was the main reason, is the file had not progressed. Again, the findings do not demonstrate that close attention to all the circumstances has been given.
So I understand your argument is that the judge committed error in finding your client unfit. However, the department and the child are arguing that the judge committed error by not terminating his parental rights. So I just want to give you an opportunity, if you wish, to respond to, I expect that, and they've stated it in their briefs, the issue of the judge not considering the department's plan of adoption when determining the best interest of the child.
So, Your Honor, they did. This is factually erroneous. They did consider the plan. I'm sorry, I didn't write down what exactly was it, but I have addressed it in my reply brief. But they definitely considered the adoption plan.
Okay, and then the judge found the mother unfit and terminated her rights, finding that it was in the child's best interest to terminate the mother's rights, but yet didn't do that for the father. So I'm just trying to figure out how to reconcile that, right?
So, yes, Your Honor, so the right to, parental rights are more than just custody, right? If she kept her parental rights and she was only found unfit, she would have the right to participate in the proceedings. She would have the right to review her determination, and basically the judge found that she should not have that right because she hadn't participated. There was no hope for her to ever become fit.
But once there's a finding of unfitness, right? Once the judge makes that finding of unfitness, then we move on to the second part of the analysis, which is a judge is required to determine whether or not the evidence supports that it's in the child's best interest to terminate that parent's rights. So he did that for the mother, right? And so if he found unfitness for the father, and I know you are,
Right.
You're objecting to that, but let's just say, for argument's sake, if we agree that the judge did have enough evidence to find your client unfit, then how do we, again, I come back to how do we address that discrepancy that he did it found that it was in the best interest to terminate mother's rights, but not the father?
Well, I think it was, the finding was, and correct me, I did not spend that much attention on the findings with respect to mother, but the findings were it was in the best interest of the child for her rights to be terminated, which does not necessarily mean freeing him for adoption. It means excluding her from any further proceedings. This is the only way I could reconcile it.
Thank you very much.
I am already over, thank you, and I'm, of course, resting my brief.
We do have your brief.
Thank you.
And next we have counsel for the child.
Good morning. May it please the court. My name is David Runkle. I'm here for the cross-appellee appellant child. This is indeed an unusual case. I want to be, I'm sorry.
Well, I want to give you a chance to.
Okay, yes. I'd actually like to begin where we left off, which was discussing this discrepancy in the judge's findings and the rationale presented, and a large gap in reasoning that fails to explain how a parent could be found unfit and into the foreseeable future, which is not necessary language. The judge added those words, based justly on father's choices. But then, when we ask, is the extreme step of termination in the child's best interests? And that is where we have a mountain of evidence that says father cannot, in the most basic ways, meet child's needs.
So can I ask you, how do you distinguish Leland? Because the facts in Leland, right, are actually in that case, there was no approved, the ICPC was denied.
Yes.
The father, arguably in that case, the parent in that case was doing less than what the father in this case was doing.
Yes.
And the appeals court reversed.
And
so help me reconcile.
So I apologize, I'm not familiar exactly with the facts of Leland, but I believe Nancy is a better case for me here. Nancy says that after 5 years of ample opportunity, a parent who cannot demonstrate any meaningful engagement with the issues that confront them, and in Nancy it was a drug addiction, and here it is a profession. I mentioned that a profession by father's choice, and he runs his own business. And at trial, he testified that, and there's a disturbing pattern here where, and father pointed out that in the beginning, the visitations were more regular, everything was going smoothly. And then the first ICPC happens.
It's approved.
It is,
This is what
yes.
I don't understand in this case, and maybe this is more a question directed to the department, like why the department, the decisions they did in this case, they had not one, but two. In fact, the first ICPC was approved, then the department said, well, now we want father to, it was like they kept moving the goalposts, right?
Yes,
And it's like,
yes.
okay, well, now you need to get a hair follicle test. He's like, okay, fine. He eventually does that. It's negative for everything for marijuana. I mean, I don't need to, I know you know the facts, and then after all that time, the ICPC expires,
Yep.
so then they have to resubmit it, and then it gets approved again, and the department still doesn't place the child with the father. So
Yes, I understand your confusion. And first, an ICPC is from Connecticut is not a mandate to.
No, I understand that,
right.
but still.
But that first ICPC revealed information that Massachusetts DCF had not had previously, and that was because father chose to not be candid. There was information about a partner, Miss K, that is back and forth at best. At times, father says they're friends, there's no relationship, they're fiance, it's unclear. Massachusetts DCF wanted more information so that they can engage with this potential caregiver. And if that was such a simple issue, why would father not be candid with it up front? I want to bring attention to, so I spoke about the degrading pattern of father's relationship, and fathers mentioned this in regards to DCF. There's a degrading pattern of relationship with the child. Over years of missed visits, late visits, canceled visits because father can't decide whether to be in person or virtual, canceled visits because father doesn't like virtual visits that are held in the foster home. The child has learned what to expect from father. And to me, the most tragic element in this case is that child's approach to father is not of hatred or it's confusion and neutrality at this point.
The child has enjoyed the visits. The indications are generally good that the child has a positive relationship.
At times, the visits have been good. At times, the visits have caused the child confusion when the father raises questions about how the child spells his name or what last name the child chooses to use. And that's an example where the father is taking parenting time that's given him as an opportunity to build a relationship, and he is leveraging it to wage a fight, a legal fight. He has forgotten, and he missed the point of the past 6 years was to demonstrate that he can be there for child, not that what he faces is unjust and that he should be forgiven for it.
Is it fair to ask how many instances the judge's findings reflect that the father confused the child in that way in that 6-year period?
I can think of at least one. If you would like more, I could find.
It was just in
Yeah.
the big scheme of things, does
Yes.
that not
Well-
suggest that maybe it was the isolated incident and not the norm?
Well, for me, I would say it probably, while I'm thinking of an isolate, it's a large issue. It's the issue of the child's name. And in this case,
I don't want to take up too much of your time with that. That was just.
Sure, yeah. But the child chooses to use his mother's last name, and the father disagrees with that. And he uses parenting time to wage that argument. For what benefit to the child?
Can we talk about the termination decision or lack of? And so, do you feel that I think actually you argue that the judge did not really consider the adoption plan, right? In terms
Yes.
of determining whether it was in the best interest to terminate the father's rights?
Yes. Yes, and I say that, I understand that can be an odd, because he certainly mentioned the plan. But there's an odd contradiction that leads me to believe that he did not fully properly consider it, which is, and you reference it, but on the decree terminating mother's rights, he also indicated that the adoption plan proposed by DCF was in best interest of the child. So that's even going further. It's how can a plan be in the best interest of the child with respect to one parent but not the other when the central issue at hand is the child?
He didn't. The judge. There aren't findings really, right, about whether the plan of adoption is in the child's best interest. It doesn't.
Other than the implication, so this is in Record Appendix, it's at the end, 98, I believe. It is at the bottom of the decree terminating, and it is part of a form, but it is a form that a judge
But
completed.
I mean specific findings that the
No,
judge.
right.
I didn't.
Correct, yes.
So should this case be remanded to have a judge make that determination?
No,
and
so I
consider-
realize, child is asking for the extraordinary remedy that this case be remanded, but that because of the unique circumstances and what is in evidence, there is nothing else that needs to be collected. Everything was before the trial court, and everything regarding unfitness and continuing unfitness was properly considered. The main issue with this case is the question at the end, which is how does the continuation of temporary circumstances serve the best interest of the child?
Right, but that's what the judge said. He said,
Right.
I find the current circumstances are in the child's best interest and to have continued visitation with the father, right? Which
Yes.
is not, I agree that the adoption plan is in the child's best interest.
Right, but I would also say that simply saying the continuation of current circumstances, which current circumstances? Certainly not all of them, right? We need permanency for this child. So it is Nancy that says, at a point,
But,
it's.
yeah, but the problem with your argument, though, it seems that in every case, once unfitness is found, that we have to, rush right to termination. I mean, the judge here seemed to be, before kind of going over the cliff, saying, well, wait a minute, we don't have to go that route.
Yes, and I do not want to conflate the two steps. They are different steps weighing the same evidence. A conclusion in one is fine if it's contrary to the first, but there should be some explanation. We can't implicitly trust reasoning that suddenly shifts course without any explanation.
Right, and the judge makes, that's why I'm trying to reconcile a lot of things, and because he says in his findings, and this is on Record Appendix 74, how do we, so he says the father's unfitness shall remain for the foreseeable future.
Yes.
Right. And then there's no,
My guess for this reconciliation is that the court, and this is just my guess, because there's nothing I have to guess, the court viewed termination of parental rights as a punishment that father did not deserve, instead of asking, what is the necessary step to advance child's best interests? And the court had everything in front of them but could not go over that ledge because they felt, I don't know, hesitancy, they couldn't explain it. But
doesn't that
they
call
need to
for-
explain it.
but doesn't that call for a remand so that the judge can explain
I
why,
believe-
why the adoption plan is or isn't in the child's best interest?
Perhaps, but it is unfair to ask the child to wait for that any further. Thank you. If there's no further questions, I rest on my brief.
Thank you very much. and counsel for the department.
May it please the court, Jeremy Bayless for the Department of Children and Families. I think a good place to start is by looking at the child, which feels strange for me going last and starting with the child as the department, but nonetheless, here we are. The difference between this case and Leland, a big one, is that this child has special needs. They require stability, they require consistency, and they require support due to educational delays and speech delays. And this isn't just the probate court making that determination. That is credited testimony from an expert witness. And so what we have is we have a parent who's not able to, unwilling or unable, it doesn't really matter, to provide consistency to the child. Not just was he unwilling to work with 3 different social workers, not just the one he accuses of discrimination, but really any of them, to make a visitation schedule he could attend. He also would confirm virtual visits and then not show up. He confirmed in-person visitation at least one time, and he only had roughly 8 in-person visits, where they brought the kid to the visitation center and father didn't attend.
But in Leland, though, the father in that case also visited sporadically, missed scheduled visits, was out of contact with the department and the child. So,
and that's why I started by looking at the kid and saying that this child has needs beyond your average child. And so the impact of that behavior is much more relevant to harm to the child and risk of future harm to the child and in an evaluation. So I guess more accurately, it's in Leland, the service plan tasks father wasn't participating in were not, the court found, reasonably tied to a parental deficiency. These, what father's behaviors that are being noted by the court, are tied to a specific need of this child. We also, in this case, have credited expert testimony that this child is bonded with their substitute caretaker, that the severance of that bond would be harmful to the child, and that father would not have the capacity to address that harm. While in almost every case involving bond with a caretaker, it is merely one factor among many. And in this case, it is also only one factor. But the case law is clear that if it were to rise to the sole dispositive factor, what would be necessary is expert testimony that we have here. So it wasn't dispositive, but it was significant. And so it's not just the case that the department and the probate court were seeking to punish his father for not getting along with the department. Obviously, we do not do that in Massachusetts. It is the case that father's general obstinance and conflict with not just the department, but with everyone who's been involved with this child. He communicated well with the grandmother who had custody, and then that relationship fell apart.
right, but it can also be said, right, that, I mean, he was cooperative more so in the beginning. He was consistent with visits, and actually there were no concerns with visits for, a while, right? And then he kept asking for more visits, and he wanted to move because he lived in Connecticut. He kept asking, right, why? Because especially after the ICPC was approved, and this is what I don't. I won't repeat myself. You heard my questions before. So we had 2 approved ICPCs, and yet the department didn't.
And I think the problem, the reason.
And then he kept complying, though. The department said, well, do a drug test. He did the drug test. Do the parenting class. He did the parenting class. Do the assessment. He did the assessment. So you can understand why, right, he might have been continuing to get frustrated with the lack of progress when he was doing what was being done.
Him being frustrated is understandable. The problem is, while he was doing everything that, for lack of a better phrase, was easier for him to do. But the problem is he had a child who he had not adjudicated paternity for several years of the child's life, while the child was in substitute care because mother was unable to care for him. And during that time, the child developed relationships with other people, and the child was in limbo. And so the department was asking father to take affirmative steps to build a relationship with this child. And while father was asking for visitation to happen only the way he preferred it, we had a child who was in a placement in one location that they had relationships with that were near the maternal family, and father was unwilling to create a schedule that would work. He would not do virtual visitation because he didn't like it. When he was doing virtual visitation because the COVID pandemic required it, he wasn't participating consistently. So he wasn't working to build that relationship with a child who needed consistent efforts to succeed. And so that's really the distinction there, is that father was doing the things he could do in Connecticut, but to have the relationship with this child, to be able to care for this child, not a child of normal or ordinary needs, he needed to be taking those steps to build the relationship, and that's what he wasn't doing.
So did that really come down to an issue of visitation then? Is that really the central issue from the department's point of view?
It is central. I think the bond with the foster family is significant. Again, in this case, this child's needs raise that to a higher level, particularly when they're the ones that are providing the consistency, that are helping him progress through the delays that he had. I think that while we don't punish people for not getting along with the department, the not getting along with the department is actually sort of a volatility that is present beyond just DCF, because he had a positive relationship with the grandmother and then that fell apart. He had positive interactions with the foster parents and then that fell apart. It's not just the Commonwealth that is causing that. It's father works well so long as things are going how he likes them to, and then when they don't go the way that he wants them to, those relationships blow up. It's father being cagey with his partner, who I believe by the time of trial was openly a fiance, who has some level of criminal record, who had a breathalyzer in her car at the time of trial, and who would be a caretaker for him. And that concealing of information in conjunction with the other factors that, as we discussed, sort of distinguish us from Leland, were enough for the court to find father unfit. Do you see my time is winding down? So I'm happy to answer any other questions on unfitness.
What was the precipitating event that caused the department to change from reunification to adoption?
I don't recall a specific precipitating event. I think it was that this child has been in care for years, and father has made really no indication that he's going to change his approach. And that was what the court found with regards to, at the time of trial, that father was unfit and that father was unlikely to become fit in any reasonable amount of time, and is...
But then didn't terminate.
I know, which is strange, because the first half of that is written exactly like a conclusion that is going to terminate parental rights. And I think the problem is that the court erred in applying the standard. The standard is, part one, we look at unfitness. Is father fit? And understanding we're on appeal, let's say that's yes. Then the second part is not, is father's unfitness so bad that he deserves termination? Termination is not a punishment. It is, does the child's best interest require termination? And the court didn't really make that second transition as to father. Because as we know from Nancy, as we know from countless cases, childhood is fleeting. Children have a limited amount of time to develop as children, and they need stability. They need to know what's going to happen. And this court's order consigns this child to indefinite foster care, because it's explicitly found and concluded that father's not changing his behavior, father's not improving anything that he's doing. And so the question then is, what is going to change? And the findings kind of make it clear that nothing is.
Can I ask, do you know if the father or anybody else really has filed a motion for a review and redetermination?
I don't believe they has as of yet. I am not sure that they can while this court has jurisdiction, but they certainly have the ability, assuming that this court just affirms the status quo below, there is the ability to do that, sort of, I believe, as soon as that decision is entered. But I don't know that they would have the ability to seek review of a decision that is currently on appeal. But even if they did, it hasn't happened. And so, first I'd say that there's an error in law in applying the standard, but even if the court did consider father's sort of level of fault, how much can be attributed to willfulness versus just unfortunate circumstances, that's still erroneous. because for the reason I stated earlier, I guess I'll take the last couple of seconds I have to say that I think I have to disagree with my brother. I think a remand is necessary because
I'm sorry, you think it is a remand?
is necessary because the court didn't get to the department's plan because of its initial error in not terminating. And if the court is terminating parental rights, it needs to make that plan analysis, and father needs to have the ability to present a plan. And so I think that would be the appropriate outcome. And I'll rest on my brief. Thank you.
Thank you. Thanks very much for the helpful briefing and the very efficient arguments. Our third case this morning. And counsel, just as a reminder, this case is impounded. Please don't use names. Speaking for myself, it might be helpful if you would use relational titles to refer to the parties because their initials are somewhat similar.
Good morning. Should it please the court, my name is Jack Kudleski. I represent the father in this situation. EL is the defendant appellant. This is an appeal regarding a 209A restraining order that was granted in the Northampton District Court. And the appeal arises from the denial of a motion to dismiss. The grounds of that motion to dismiss being the order as granted in Northampton violated the doctrines of collateral estoppel, judicial estoppel, and the court in Northampton lacked subject matter jurisdiction to issue the order.
Can I ask a question? Is a restraining order by its nature absent an order to make it permanent, a temporary creature? Is a restraining order, a 209A restraining order, is that temporary absent a specific finding that it is permanent?
Yeah, I would say it's temporary. You have to come in every year to get it extended, and it's an open question of whether it's extended. So, and it's always subject to modification. So, yeah, I would agree that it's temporary.
So I know that you have other arguments, but if we were looking at the PKPA argument, is it not true that Massachusetts, even if it were not the home state, would have the ability to issue temporary orders to permit and then to permit the home state to act after the temporary order is issued?
I think there's an exception for emergency, Your Honor, for example. But
why doesn't this fit that category?
That was considered in Greenfield. That was raised in Greenfield, and the court didn't find an emergency. So it's not like that didn't come up, Your Honor.
Yeah, but this is an appeal from what happened in Northampton, though, right?
Yes.
Okay, so why isn't it an emergency? It's a 209A.
Well, I mean, if only because a year had elapsed. I mean, we could get into the facts. That really wasn't my argument, but, you know, that was addressed in Greenfield. There should be a no contact order put in place between father and child, daughter, was considered and denied. And then the same request was made in Northampton. So whether or not that could be the case, collateral estoppel would have prevented relitigating that issue.
Well, yeah, but aren't we dealing with different parties and different facts?
The parties and facts are exactly the same. In Greenfield, the order was requested by the mother with provisions on behalf of the daughter. In Northampton, the mother was acting on behalf of the daughter. These are parties in privity. They're nominally different. The names are different, but the privity is the same.
So I have a question about venue. So the first 209A was issued and extended out of Greenfield, right? And then the parties went back for the extension hearing a year later, and then that was denied. And then the plaintiff, I'll call her the plaintiff of the 209A, went to Northampton after that. So I assume there's no venue issue with respect to.
I don't know. I'm not aware of where the plaintiff resides, or so if for all I know, yes. I don't know. Could be. I don't know how it could be both Greenfield and Northampton.
There was a suggestion that that the mother had moved, if I'm not
Yeah, I remember that.
remembering incorrectly,
coming up
between
on
the issuance
record.
of the Greenfield order and the issuance of the Northampton order?
Yes, I believe that was represented, but my ability to represent that or affirm that, I'm not able to do that.
Do you have a precedent to say that the ruling that the Greenfield judge made on the allowance of the motion to dismiss at least so much of the restraining order as prevented contact between the father and the child was a final judgment?
Well, that part of the order was dismissed. As far as a case that comes to my mind, no, but I didn't research that issue. If I can submit a letter.
Is that necessary for your collateral estoppel argument?
I think there has to be final judgment. That is part of the issue. And, I would say that their final judgment exists, I don't have a case that I could cite, but when, a motion is dismissed on the exact same grounds that are being presented in a different court, I would say that, yeah, final judgment has occurred in Greenfield. Yeah.
But there was no, am I right about the fact that the Greenfield order was not terminated? The Greenfield order was continued, it was just limited, is that correct?
Yeah, what happened, Your Honor, is that there was an extension hearing for the full Greenfield order, which was provisions insulating the mother, along with a custody determination and some other orders flowing therefrom. We returned to Greenfield and agreed that the orders, as far as they go to the mother, can continue. We weren't contesting that. We were contesting the issues regarding the child because they were creating so many problems in Washington State. The Washington State court couldn't proceed with their ability to determine parenting plan and their custody because they couldn't allow for contact. So they couldn't have video visits or anything like that because if Dad participated in what Washington was ordering, they'd be in violation of the Massachusetts order.
So the Judge Manzanek's order in response to your motion to dismiss, I'm not trying to put words in your mouth, but am I understanding correctly, was essentially a modification of the existing order issued in favor of the mother?
I guess you could say that, Your Honor. Okay. Yeah, but I mean, it was by agreement and, yeah,
It was by agreement, the judge agreed with you.
Well, there was no hearing on the issues as far as the mother went. We simply agreed. The issue was the portions of the order that had to deal with the child.
Okay.
This order has expired, right?
This order has expired.
So why is there's no interstate issue whatsoever, right?
As we're speaking right now?
Yeah.
No. I think that this would fall into the category of cases that could arise factually. Another
So it's just speculation. In other words, there is no real controversy right now between states.
I agree that this situation would be moot as we're speaking factually.
I'm sorry, would be moot, is that what you said?
Factually, as we're speaking right now, it's been resolved. But it wasn't resolved for lack of the plaintiff trying to extend this order. We went back into Northampton, and there was an attempt to extend this order, despite the representations when it was originally granted that this would never arise again. We just needed a little bit of time to sort things out in Massachusetts and take care of things in Washington, and then poof, we're back in Northampton, and they're asking for another extension.
No, but based on what's in the record before us, though, as I read the docket, this order expired.
Yes, sir.
So if that's the case, Washington State has a free hand to do whatever it wants as far as custody and visitation.
And my understanding is that is proceeding. I'm here because this is an issue that could arise again. What happened was troublingly wrong, frankly, that, because of playing fast and loose, Dad couldn't have a conversation.
Yeah, but let me ask you this, because there is, it seems to fail a common sense test to me, because let's just take a hypothetical that, let's say, parties all, mom, dad, child, all live out in California, let's say. Dad files for divorce out in California. Mom and child come to Massachusetts. Dad then comes to Massachusetts and is kicking the door into the residence and is threatening mom and child, I'm going to kill both of you. Are you saying because there's a pending divorce action in California that the Massachusetts courts are powerless
No.
to issue a 209A?
No, I'm absolutely not saying that. I'm saying that if there's going to be orders that affect custody, the court in California, in your hypothetical, needs to order them. Massachusetts has the ability to enforce restraining orders from another state. If that is if the law, as I'm suggesting, is followed, someone in that hypothetical wouldn't be unprotected in that scenario. All I'm saying is that these issues that would prevent custody from being adjudicated need to be handled in the original home state jurisdiction, so they can do it in a way that lets them do the parenting plan. But if there is an abuse prevention order or a protective order in Washington, which I think there is right now as we're speaking, that is enforceable in Massachusetts if it's violated. So, yeah, I don't think that the hypothetical you're proposing is a real risk, no.
So I'm not following you. So if in my hypothetical, a court issues a 209A order, stay away, no contact with the child, you're saying now that, okay, that doesn't affect custody or visitation?
I'm saying that if a court was to order no contact or type of contact or staying away, the court that needs to do that is the same court that is determining the parenting.
Oh,
Which is
okay, so you are saying that the Massachusetts court is powerless to issue that 209A and enforce it? You're saying it has to come from California, in my hypothetical?
It wouldn't be, if it was an emergency, we know that there's an exception. We already talked about that. So if there is someone kicking down a door in Massachusetts, I could see a judge saying that's an emergency. But besides some exception to the PKPA, no, Massachusetts can't issue a restraining order that interferes with the home state jurisdiction to determine child custody. That's the point of the Parental Kidnapping Act. But even in that hypothetical, for someone who isn't experiencing an emergency in Massachusetts still is protected by any orders that would be issued in the home state jurisdiction.
Yeah, but you seem to be reading too much into the federal statute, because as I read it, it says, for example, in my hypothetical, that 209A could issue if it is necessary in an emergency to protect the child, because the child, the sibling or parent of the child, has been subjected to or threatened with mistreatment or abuse. So it doesn't have to be as extreme as I suggested in the hypothetical. It's just threatened with mistreatment or abuse. That's enough. That even under federal law, Massachusetts should be able to issue a 209A order and enforce it without violating the federal statute.
If they find an emergency under the statute, Your Honor. But again, when we're not talking about a hypothetical, we're talking about what actually happened. And what actually happened is in Greenfield, that issue was raised. The judge considered it, the same judge who heard the original order, and the judge said there wasn't an emergency and granted the motion. And then the litigant got in their car, drove 20 minutes to a different court, and took another bite at the apple. That seems plainly wrong to me. That's why the judicial estoppel argument isn't there, because that's a problem. That's why the collateral estoppel argument isn't there. That's why the Kimbrough-Tillery case exists. So people can't just travel all over Massachusetts and go to courts until they find a judge that agrees with them. Are there any other questions?
No, thank you. I think we have your argument.
Or so my brief, thank you.
Thank you. The case is submitted. Our fourth case this morning is William G. Lufkin and another versus the Commonwealth of Massachusetts and another, 2024 P0611.
Good morning.
Morning.
This case is primarily under the wrongful death statute, Chapter 229, Section 2. Just as one approach to this, because I'm assuming I don't need to go into the factual kind of timeline in much detail, but I'll come back to it if I need to. So just as a thought experiment, our case, the plaintiff's case, would it go to trial, has some very basic elements.
Can I ask one of those? Can you clarify for me who the defendant or defendants actually are here?
The defendant, sole defendant, is the Commonwealth.
Okay, thanks.
I thought we conceded in our opposition to the motion for summary judgment.
There were some plurals in the
And
briefing
then
that
then
were.
it did show up again in the appellate brief, and so I apologize for that, because that was put to bed, I believe, at the motion for summary judgment. So at any rate, the evidence, just in very broad brushstrokes, if you will, would be that when William Lufkin was brought as a federal detainee to Plymouth House of Correction, through his admission until the time he took his own life within 24 hours, was not offered a telephone. That's in contravention or contradiction to a statute. So that's Chapter 276, Section 33A.
But with respect, and I appreciate the truly tragic situation that this presents for your clients, that lack of a telephone call is not something that you're arguing is a direct original cause of the loss here, is it?
No, it is part of the constellation of facts that the jury would be asked to consider in evaluating essentially the negligence claim.
But at best, those factors that you're describing, including the phone, and I understand things like the presence of the laundry bag and certain other issues, the solitary or the placement of your client's son in a specific location within the jail, those may be facilitating or contributing factors to what ultimately happened. But as far as original cause goes, can you explain to me how those amount to original cause?
So both under the statutes for the Commonwealth and then those adopted through policy and procedures within the institution, both the DOC and each institution, or the Department of Corrections and then the county sheriff's department, adopted protocols and for the reduction, minimization, if you will, of suicide within the institution. So that was part of what they acknowledge. And because under statute, a detainee or other applicable law, but also an inmate, as distinguished by temporary versus incarcerated pursuant to sentencing. They're both in the custody of the institution, in this case the Commonwealth of Massachusetts and Plymouth House of Correction, and there's a duty to protect them, to feed them, to give them medical care if necessary, mental health care, and specifically here and relevant here is ameliorating any substance use issues, especially for a detainee that newly arrives. And so there was that initial screening process. His paperwork showed that came in with the U.S. Marshal's office that he had, there was specific language in it that he abused drugs. So he was interviewed by a medical officer, not their medical officer, that's not a physician within the House of Correction. And she interviewed him. It's predicated mostly on self-reporting and then she asked him questions about what drugs and how much and how often. And that's in the brief, that he had indicated he was a daily user of benzodiazepine, Percocets, and alcohol. Although she expressed, and I think we included that paragraph, suspicion of any detainee coming in and that she's screening, because self-reporting can sometimes lead to receiving drugs in the institution to assist with the symptoms of detox. And so she allowed for that, but she said in this case she was suspicious enough that it was, or suspected, that she placed him on this detox protocol. And that was to require a medical officer, again, not a physician, but it would appear 2 times a day to check vitals and to have a conversation, to see where they were. In addition to that, one of the things that was violated under the policy was, under their express policy, was that if there was suspected drug use and issues, that they were to see the facility physician. And that never occurred in this case.
And I'm sorry to interrupt you, but assuming all of this is undisputed, which it seems it is, and that there's a negligence argument to be made, one of the considerations, or one of the issues on appeal here is whether there's immunity from liability for that negligence under, for example, 10J, right? And 10J requires that or provides immunity for a condition or situation not originally caused by the public employer, right?
Yes, so.
Okay, and so if with your argument, if it had been an issue where your client's decedent had died as a result of a failure to medically detox, and that was the reason, and I understand you're arguing that that played into potentially exacerbating the likelihood of your client's death as it happened.
Increasing the risk of suicide, right? That was the whole.
Okay, but the originating cause, why is the originating cause in this situation not the decedent's own mental state and the ongoing depression issues that he described experiencing in the note that was left behind?
Because the facility, in adoption of protocols and procedures that are supposed to mirror the statutes in the state for providing mental health, general maintenance of a human being under certain circumstances, that's part of our law. In adopting their own procedures and protocols, they're responsible for all of those issues, including suicide prevention, because it is in some regards epidemic within institutions, especially when they fail to follow these procedures. Can I just complete that answer, because I feel like I'm leaving all these tails hanging out there every time. So that my point was that that was the broad brush of the case. That's what a jury would be asked to evaluate the credibility and those issues. The trial judge, Judge Glennie, instead takes this, first of all, it's 10A, and says that the discretionary function applies to all of these issues. I would suggest, and I can get into the case law, but it's pretty clear from the seminal cases that it's not meant to apply to any matter where there is discretion, because implementation of discretion isn't anything that involves an interaction with an inmate or a probationer, a social worker. All of those things have discretion in their job, and that's not what's meant by the court. And there's very good dicta and important seminal cases on that they're separated, that this is more aptly, and I would say that this is that case, described by a negligent implementation of already existing policy and planning. So the policy's there. How was it implemented, and was it negligently approached and implemented? What did they do? And so the failure to put in or to upload this prescription for visits and vital sign monitoring is an example of that negligent implementation of policy. Not an example of what the court was looking at with discretionary function. There's the case, it takes place, I believe, in Lowell, involves the sprinkler system, and I'll find it for you, but when the 5 or 6 story building was on fire, the fire department arrived, they hooked up to the fire hydrants, and what that did was drop the pressure, the sprinklers were diminished, and the building burned down. Found not to be a discretionary function. There's Greenwood, I think it was Greenwood v. Easton, which is telephone poles using to line a parking lot, but they weren't secured, and so someone hit one with a car, it rolled over a woman's leg, and she was injured. Discretion to use these extra telephone poles in the manner that they were going to be used in planning. Not a discretionary function to failure to essentially install them correctly. That's not the discretionary part. So, and there are other cases, and I'll certainly identify them. I think one that's right on point involves the probation case, because I think it's very similar, if I can just find that. Okay, that is, it's abbreviated A period, L period versus the Commonwealth. There's a companion case, and it's 402 Mass at 234. Although there's some other issues with that, the issue with respect to discretionary function was resolved with the court finding that the probation officer who used discretion with a small d every minute of every interaction with their client or their probationer, but that was not the discretionary function of policy and planning. The policy and planning had been set, and what they were doing was negligently applying the policy that resulted in a third party, in this case, being harmed by those acts of the probationer. So, Your Honor, I understand that I'm sorry, Justice Tan, I did not respond. I didn't hear your question.
That's okay. I just wanted to go back to this question about, can you talk to me about how do you distinguish cases that have held, for example, Paradise versus Frost, which is cited by the defendants in their brief, where we've interpreted 10J to provide immunity, from claims based on failure to prevent suicide. And in that case, in the Paradise case, involved a high school student, and the court found that the student's suicide was the result of his own state of mind and not the failures of, in this case, it was a high school social worker not reporting concerns that were raised to her about the student to the family of the student. And so the court there said that the original cause must be an affirmative act, and the failure to act does not suffice, and that the suicide was the result of the student's own mind and not the failures of the employees. So how do you address kind of the
and I'm sorry to start by answering a question to the three of you with a question. Is that I'm just having trouble remembering, is that the YEAW case, Y-E-A-W?
No, Paradise versus Frost involves a high school student in Acton.
Sorry.
But I guess just conceptually, they're just generally speaking, how do we deal with that?
At least in that case, and I'm not sure if it tracks this, but at least in that YEAW case, they were monitoring an individual for suicidal ideation, and were treating that individual for suicidal ideation. And I think the distinction here is that, we have this confinement with Billy Lufkin, where he's undergoing potentially dangerous detoxification. And so, without monitoring him in isolation and all these other things, they had created the actual circumstances, not to mention providing literally the rope with which, he killed himself. So that, I think there's some distinction. I don't remember the fact pattern, I'm sorry. I would take a minute and do it, but I'm almost out of time. The distinction, at least, that Judge Glennie decided two things. One is that everything was, they were immune to all those decisions as a result of the discretionary function. And I would suggest to you that's just simply not true by the case law. It's a misapplication. It's yes by words, but that was not the holding of seminal cases that are in our brief, and they're in our page on the opening page. With respect to 10J, this idea that that the nurse who essentially prescribed a certain protocol for him that did not implement him was not immune pursuant to 10A, but instead it was 10J because it was analyzed under third-party conduct. Third-party conduct. I'd suggest that that's quite a gymnastics to get to third party for the individual who was injured here. It's not a third party. It's suicide prevention policy within the institution isn't dealing with third parties. It's dealing with the individuals that may be undergoing psychological issues, involved, have as an enhancement drug issues, but they're first person, they're first parties. They're the ones that are named, they're being dealt with, they're identified, a protocol is designed. So it shouldn't be analyzed as if another inmate attacked William Lufkin and caused him harm. Clearly not our fact pattern. And that allowed Judge Glennie then to say, well, there was no positive or direct step, that it was an omission. And I would just say it's shoehorning our facts into other cases that are not, they're inopposite.
We have your argument, I think, and we're going to have to call it time.
Thank you.
Thank you very much.
It please the court. Good morning. My name is Patrick Lee. I represent the defendant in this matter. The Commonwealth shares the court's sympathy for the decedent, for the family. Anytime a young person takes his own life, it's a tragedy. But this case turns on legal immunity provided by the Massachusetts Tort Claims Act. And I'd like to start by focusing on where the court started its questioning regarding 10J. 10J under Chapter 258 provides that the Commonwealth has immunity for a failure to prevent harm or to diminish harmful consequences of a situation or condition not originally caused by the Commonwealth. And that includes third-party tortfeasor conduct, but the language of the statute is much broader than that. And the Paradise case cited by Justice Tan is a very clear example. That's a suicide case where the decedent himself was the original cause of the harm that befell him. McCarthy is another suicide case decided by this court where the decedent's suicidal state of mind was the original cause of his harm.
In this case, does the third of the exceptions to 10J apply for negligent medical treatment?
I'm sorry, I didn't hear the
So 10J, as I understand it, has three potential exceptions, and the third of them is where there's a claim involving negligent medical treatment. Does that apply here? And that's different, I think, than Paradise?
So the plaintiffs never raised that. This was never brought as a negligent medical treatment case.
Right.
And so I would suggest that was not raised at the summary judgment level. That was not raised in the brief here, and so they've waived that. I would say that that does not apply here, and Paradise actually addresses that, because in Paradise, the school official was actually a counselor, and the plaintiffs raised the argument that that counselor failed by not notifying the family of a known suicide risk. It was very clear to that counselor that the decedent had made statements or engaged in behavior where there was a risk of suicide. The counselor promised to notify the family. The counselor failed to follow up on that promise, and some time later, I think it was months later, the student took his own life. And so the plaintiffs in that case alleged that that exception for negligent medical treatment applied. This court found that the failure was not one of medical treatment. It wasn't a counseling error. It was a failure to follow through on a promise to notify the family. I would suggest a similar distinction applies here. The nurse is not accused of giving him improper nursing care. She's accused of a ministerial error of not noting something in the medical record. And in fact, Justice Glennie, in reviewing it, called it a ministerial error. So I suggest even if that's not waived by the plaintiffs here, that that exception does not apply. And so the Commonwealth is entitled to immunity. The plaintiffs were obligated to prove original cause, that the defendants were the original cause of the harm. And the courts have been very clear that to prove original causation, that the defendants had to engage in an affirmative act, not a failure to act, and that affirmative act materially contributed to the creation of the condition or situation. And that's right from the Kent case. And so here, what the record very clearly shows is that the decedent's own suicidal ideation is the original cause. And so that makes this case very similar to Paradis, very similar to McCarthy. The decedent actually expressed his own suicidal state of mind in the suicide note, which we've included in the record. He says that he is stepping out. He says that he's been depressed for some time, and this is his excuse. And so the remaining arguments that the plaintiffs bring are really just arguments that the defendants should have done more to prevent the decedent from acting on that suicidal ideation. And in that way, this case is very similar to Brum, it's very similar to Jacome, it's very similar to Cormier that we've cited in our brief. In each of those cases, the plaintiffs alleged that the defendants could have done more to prevent the harm. And essentially, they sought to hold the government actors responsible for a failure to guarantee safety. And that's the exact same type of claim the plaintiffs bring here. That's the exact sort of claim that is foreclosed by 10J. And so the plaintiffs did not meet their obligation on the summary judgment record.
But why not let a jury make that call?
Well,
because it seems to be a fact-based determination, doesn't it?
Paradise makes clear that it's a legal issue for the court to decide. This is an issue of immunity, and the Brum case makes the point that immunity issues should be dealt with as soon as possible. And by letting it go beyond a motion to dismiss, beyond a motion for summary judgment, and go to a jury, you've basically taken away the Commonwealth's immunity, because we've engaged in discovery, we've engaged in litigation at the summary judgment stage. To let it go to a jury, we'd actually have to go through a full trial to decide if immunity applies. Brum says that's not appropriate. Immunity decisions should be handled as early as possible in the process, and it's a legal issue that has to be addressed by the court.
So your position would be that even viewing all the facts in a light most favorable to the non-moving party, as a matter of law, there's just no way that this immunity is not available.
That's our position, yes. That was our position at the trial court when we moved for summary judgment, and that's our position now. And it turns, as we're talking about 10J immunity, it turns on causation. As in Paradis, the original cause is the suicidal state of mind. And the plaintiffs here have not put forth facts which showed that the defendants created that suicidal state of mind. There's no evidence to support that claim. And so it was their obligation at the summary judgment stage to come up with evidence. We presented evidence that showed a lack of evidence there. They were then obligated to come forth to show their proof, and they failed to do that at the trial court, which is why the trial court properly entered summary judgment. Turning to the issue of...
So just to follow up on that, so if the plaintiff produced an expert that came in and said, well, the decedent, got the idea of suicide based on the circumstances that he had confronted in the facility, gave him a sense of hopelessness and so forth, and he had no way out, and the embarrassment and shame of being locked up and so forth, that could survive summary judgment?
If the facts establish that the defendants themselves were the original cause of that suicidal ideation, and that's a very high ladder to climb for the plaintiffs, but in that hypothetical, that could perhaps survive the immunity claim. Now, you still have to go on and prove that there's a duty to prevent the suicide. There's still all sorts of problems with the plaintiff's case here. That's not what we have here. The plaintiff did go out and get an expert at the last minute, and what the expert highlights in his report is a lot of risk factors that he felt that the defendant should have identified early in the process. And all of those risk factors that he identifies are things that we did not create. So he talks about the first time in jail, substance use, detoxing, unemployment, social isolation before his incarceration. The defendant's conduct caused none of those. When he turns to something like assigning him to segregation, what he talks about is it served to exacerbate a risk. But if it exacerbated a risk, it doesn't create that risk. And so on the record you have before you, the plaintiffs did not show that there was original causation. And there's an absence of that evidence. The Commonwealth is entitled to immunity here. Turning, if I could, to the discretionary function. 258 Section 10B does provide for discretionary function immunity, whether or not that discretion is abused. And for the policies and procedures, the trial court found that the Commonwealth is immune for enactment of its policies and procedures. The plaintiffs don't seem to be challenging that on appeal. The trial court went on to find that the decision not to place the decedent on suicide watch was a discretionary function. And if you look at the procedures that we put in front of the record, there's a very detailed process that employees have to go through to scrutinize a risk of suicide. And the employees went through that. There was an examination by a booking officer. There was an examination by a nurse. They asked about history. They asked about prior attempts. They asked about plans for suicide. And not only did they ask those questions, but they also evaluated the way the decedent answered those questions. And so they looked at eye contact. They looked at his tone of voice. They looked at how he held his hands. And that's really where the heart of the discretion comes in here, because you need an officer who's actually going to look this person in the eye, evaluate this person, and then make a discretionary call as to whether the individual is at risk of suicide. Our procedures give the authority to any employee to identify someone at risk at any time. And so that is a discretionary call. That doesn't end the analysis, because under the Harry Stoller case, we then have to look if that discretion is something that is geared toward policy and planning. And I would suggest that the decision to place someone on suicide watch, or alternatively not to place someone on suicide watch, clearly implicates planning, not so much with the policy making, but involves planning, because the impact of that decision is very significant for the individual prisoner. If the facility decides to place someone on suicide watch, they strip him of his clothes, they put him in a safety smock, they take away his blanket until it's approved by a mental health worker, they take away a mattress. He's under constant observation by a correction officer. So it has dramatic impacts on that prisoner. It also implicates how the government allocates its resources, because it has to assign a correction officer to watch this person. And it's a security determination. It's something that the executive has to decide the best way to keep someone safe. And that is the heart of planning that's covered by 10B. And so we cited the Doe case, which is Doe versus the Massachusetts Trial Court, where they talk about security decisions are integral to government policy and planning making, because they weigh alternatives, they decide how to use limited resources, and ultimately they're geared towards keeping people safe. That's the exact same sort of analysis that goes on when the correctional officials have to decide whether to put someone on a watch. Before my time is up, I would like to address the alternative grounds that we asserted at the trial court. And the court did not reach these alternative grounds because the court ruled on immunity. But the primary argument that we raised at the trial court for summary judgment was that under the facts that were undisputed in the record, a duty to prevent suicide was not actually triggered. And so in the Slavin case decided in 1982, the Supreme Judicial Court said that in areas where there is a duty to prevent suicide, that duty is only triggered when the defendants knew or should have known of a risk of suicide. Now, most recently in 2023, this court came up with a very specific application in the Bonafini case. And they were applying the standard that had been set up by the Supreme Judicial Court in the Wynn versus MIT case. And this court established that to meet the standard of know or should have known, that there has to be one of two things: actual knowledge of a recent attempt or stated plan. And none of those factors exist here. It's undisputed that the employees did not know that this person was suicidal. They specifically probed that. They asked him specifically if he planned to harm himself. They asked him specifically if he had tried to harm himself in the past, and he answered in the negative. But beyond that, the record shows very clearly that no one was in a position to know. The parents, the plaintiffs themselves, did not know that he was suicidal, that he was depressed, that he was abusing drugs. He had never made any prior attempts to their minds. He had never made any statements to their minds. The attorney who had brief interaction with him in court was shocked when he found out about the suicide. And then once he gets to the facility, all of the officers and other professionals who interact with him see nothing to indicate that he's at risk of suicide. There's certainly no evidence that there was actual knowledge of a recent attempt or a threat to commit suicide. And so because of that, the duty to prevent suicide was not triggered in this case, and that's another proper ground for summary judgment. So I see I'm nearing the end of my time. Unless there are further questions, I'd rest on my brief.
Thank you. Thank you both for your briefing and arguments. The case is submitted, and that is the final case that we have on our list today. I'd like to thank the court officers for their help, our court law clerks for their help, and all of the people who have appeared today for the excellent arguments. With that, court is adjourned.
All rise.